Good afternoon, everyone. My name is Ken Coates. I'm a senior fellow with the Macdonald-Laurier Institute. I'm glad to welcome people from across Canada. We have many hundreds of people joining us today, and I'm delighted with the level of interest in this webinar. Delighted with your support for the project and for trying to get things right with Indigenous folks all the way across this country, from coast to coast to coast. The webinar today, Understanding UNDRIP, Challenges to Legislating the United Nations Declaration on the Rights of Indigenous People, comes at a very critical time. Obviously, the House of Commons and the Senate will be in the process of reviewing Bill C-15 and the legislation surrounding UNDRIP. We have assembled a really great group of people here who have some very important and interesting perspectives to share. We've received a bunch of questions already from the enthusiastic ones amongst you who sent us in queries that they wanted us to ask the panelists. Let me just quickly describe the format. We're going to ask a series of questions to our panelists. We'll go through them fairly systematically and fairly quickly. I'll introduce the panelists first. And from that point, we were then going to have a series of questions that come from the audience. We did receive a bunch of those questions ahead of time, and we appreciate the interest and the taking the initiative to do that. So thank you very, very much for those. But we also encourage you to put questions in the chat. So if you have a question as we go along, or something you want to talk about, please put it in there. We have curators behind the scenes who will sort of correlate the questions for us and give us a chance to sort of deal with that. We hope to have about 40 minutes to have our panelists describe the situation as they see it with UNDRIP. And then we'll have about 20 minutes, about 30 to 40 minutes again for the rest of you to sort of get your questions asked by this group. We hope for a very full and enthusiastic discussion. Our panelists are terrific individuals. So let me introduce them to you first. We're going to be joined here by three people today. Chris Sankey is a Chief Executive Officer of Blackfish Enterprises. Chris is a Coast Tsimshian person calling us in from Northwest British Columbia right now. A wonderful and talented political leader, but with his very interesting sort of connections across the country in terms of economic activity. Also like to introduce Melissa Mbarki, who is coming to us from Edmonton today. Melissa, great to have you with us. Very interesting background. She's a policy analyst with the Macdonald-Laurier Institute. She's had a long history, a lot of experience working in the oil and gas sector, and comes to us with a very strong and very rich background in community affairs, has done some really excellent work in connecting her community to the broader patterns of Canadian Indigenous policy as we sort of move into the 21st century. And our third panelist today is Heather Exner-Pirot. And Heather is coming to us from Calgary. Heather, great to have you with us. Heather has her PhD from the University of Calgary and ran around chasing Arctic issues for a very long time. She's one of Canada's leading specialists in Arctic politics and international relations. She's been working in Calgary and in Western Canada for quite some time with a variety of different Indigenous organizations, working on issues of economic development and socioeconomic transformation in Indigenous communities. Heather is a huge advocate for the empowerment of Indigenous people and the engagement in the Canadian economy. So delighted to have you all with us today. Looking forward to your thoughts and looking forward to your comments. So I'm going to start off with a really easy question. One of these like slow pitch things that hangs up there in the air and you all get a chance to hit it out of the park. And sorry for the baseball analogies. UNDRIP is a remarkable international political achievement. It took Indigenous groups from all around the world more than 30 years to sort of bring this together. They had to convince the United Nations to sort of pass it. They brought UNDRIP into public effect, back into 2007. What do you like about UNDRIP? What do you like about this United Nations document? Not talking here about Canada, but about the document as a whole. And Chris, we'll start with you if you don't mind.
Thanks, Ken. I think it's a great opportunity to recognize our inherent right as Indigenous people of Canada. I'm actually quite delighted that that's actually taking place. I have noticed a significant change in the minds of Canadians with regards to the bill. As we were talking earlier, Ken, and obviously it's something that could greatly improve. But that said, the excitement for me is just now Indigenous people could start to feel that they're a part of Canada rather than being apart from Canada.
Thanks, Chris. Excellent. Melissa, your thoughts? What do you think about UNDRIP as a document?
I really like the document because it's inclusive of Indigenous people and non-Indigenous people. It's really promoting cooperation, communication, and it's inclusive of our elders and youth, women. It encompasses everyone, and I think with that, having said that, it's going to promote way more dialogue in the future, and it's definitely going to bring Indigenous issues to the forefront.
All right, thanks, Melissa. Heather, over to you.
Well, I might have a little more long-winded answer, as you might expect, but I'm glad you asked the question, because I think the discussion on C-15 has become a debate about whether Indigenous rights are good or not. And that's obviously not the debate we want to have. Of course, Indigenous rights need to be affirmed and recognized and protected. And so UNDRIP itself, or some people prefer just saying the declaration, it is remarkable document and a long time coming. And I remember for myself, just to go back to the history, I remember in 1995, Hillary Clinton said, in a big speech, women's rights are human rights and human rights are women's rights. And that really struck me. I think I was in grade 12 at the time, to think, like, how does this even need to be said? That, basic human rights are for all humans. And that was what it took, I think, with UNDRIP, is to get to that point too, to say that Indigenous rights are human rights and human rights are Indigenous rights. And that we need to respect that. And of course, that hasn't always been the case. And I think we found ourselves kind of post-World War II in the new global order of, a collection of states. And how did Indigenous nations fit into those states? And they were often subsumed or tried to be assimilated. And so I think the main part of UNDRIP that is important and that has had a lot of influence is recognizing that right to self-determination. That Indigenous peoples didn't get up their right, weren't, never consented and never agreed and never discussed giving up their own right to determine for themselves how they govern themselves, how they deliver education, how they're involved in the economy, how they use the land. And where it has already had influence in Canadian law, for example, C-92, saying Indigenous rights have their own right to govern their child and family services. They never gave that up to the Canadian state. They never agreed to that. And having something like UNDRIP provides that standard for us all to say, you're right, they have that right, they never gave it up, and we need to recognize it. It's not for us to take that away.
Thanks, Heather. My own observation, for what it's worth, is I never thought UNDRIP would get passed. And not because I didn't support the aspirations and the values and even the terms of a lot of UNDRIP legislation. But I remember in mid-1990s, I was at a United Nations meeting they held in Whitehorse in the Yukon, and they brought people from 15 different countries together, and they had a government official, an Indigenous leader, and then an NGO representative. And watching the conversation there in 1995 or 1996, whatever it was, convinced me that this legislation would never get through, because the perspective, the people from Latin America had very different perspectives from the folks from Africa. The people who were there from New Zealand and Australia are completely different from the ones in Canada. And there's no way you can ever get all these people to agree on sort of common language and common perspective. So as we sort of talk about UNDRIP, let's make sure we recognize the incredible political talent that went into actually making this thing actually come together. So let's switch from UNDRIP as a concept, and your comments were all very, very positive. Bill C-15 is the government of Canada's attempt to bring UNDRIP into Canadian law. So Bill C-15 is not UNDRIP. UNDRIP is something else. So what do you think about Bill C-15? We'll go in the same circle over this time around, but Chris, what do you think?
Well, where do I start? Look, at the end of the day, one of the things that I comes to mind when we talk about Bill C-15 is, what is the difference between this bill and free, prior, and informed consent? Since I entered politics and got into the private sector, we've always met and worked with Indigenous communities to get free, prior, informed consent. It's no different when I was on council. We always worked with industry to get free, prior, informed consent. So what is going to change this process within the bill, or if any? We're looking at Bill C-15 as a way to recognize our inherent right to making sure that we have an opportunity to build a sovereign nation, an opportunity to start managing wealth and get out of poverty. But there's all these aspects, as Heather alluded to in her opening remarks, taking care of our children, enhancing our culture and language. What's going to change? At the end of the day, this bill is supposed to be guiding us to become a part of Canada, and it's supposed to be a part of Canadian law. But that being said, so far, everything I've read, even though I like what's in the bill, how are they going to implement all this? What are they going to do, and where are they going to start? And it all comes down to money. And so I, as an Indigenous person of Canada, I don't want to continue to rely on the government for resources in terms of money to sustain our communities. Forever and a day, our leaders in our communities have always talked about how do we get away from relying on the government for funds to sustain our communities. Well, this bill do that, where we could just start to generate our own sole source revenues to take care of our elders, to take care of our housing, to take care of infrastructure, to take care of our language and culture while providing good paying jobs. Will it do that? Right now, so far, what I'm concerned about is, will this bill just be more leapfrogging than what it's made out to be?
Thanks, Chris. I mean, it's interesting. I always find it sort of puzzling that even in the year 2021, people are still surprised when somebody says what you just said, that Indigenous communities want government out of their lives. And in fact, I've heard you say it lots of times. I've heard Indigenous people across the country say it. You know, the pursuit of autonomy and sovereignty is the overwhelming driving force. So First Nations can make their own choices, not relying on governments year by year. So thanks for that very much, Chris.
Yeah. Sorry, I just wanted to add, like, for me, for this bill, I'm hoping that the intention is to get out of the way. Let us live our lives and let us build this sovereign wealth so we could move our country forward together. And that's what I'm hoping this bill is supposed to be about, that we're a country rich in resources, we're a country rich in opportunity. I hope this bill helps us remove all those barriers so we could start to prosper as Canadians.
Oh, super. Thanks, Chris. Appreciate that a lot. Melissa, same question to you. Bill C-15 is the government's attempt to bring UNDRIP into Canada, so into Canadian law. So what do you think about UNDRIP? Or, Bill C-15?
Very vague. There's no definitions. There's no definition of Indigenous, who it's inclusive of. There's no definition of land. So as an operator, or even as an external party coming into a First Nations community, who are they going to consult? Who's going to veto decisions? Who's going to make those decisions? And it's not clear in this act who is going to be doing that. The second issue that I have with it is that it just included so many different issues and initiatives. Why didn't the government just invest money in some of these initiatives, like some of the calls to action? Why didn't they just invest in reconciliation, however that looks with each province? It's not well put together. It's very vague. And I think we need to go back to it and actually make it more clear on who speaks on behalf of Bill C-15. Is it the First Nations communities? Is it our elected chief and council? Is it an activist that set up camp outside of our reserve? Like, who speaks for Bill C-15? And I think that needs to be clearly defined.
Thanks, Melissa. That's very, very important message. Heather, over to you. What do you think about Bill C-15?
I have, some sympathy for the people that, that brought this forward, that have been working for a decade to bring this. And I can see wanting to honor the work that Wilton Littlechild did, to bring the declaration about in the first place, and then to want to honor the work that Romeo Saganash, did to bring forward Bill C-262. And so I can see why for some people this represents a culmination. That, after all the work they've done with UNDRIP, to have it recognized and affirmed in Canadian law would be the next step. So I can appreciate that. But in terms of the bill itself, I think it is very poorly drafted. It is a poor piece of legislation. And I think, Ken, it's our friend, mutual colleague, Dwight Newman, who said it has interpretive difficulties, which is a lawyer's way of saying that this bill is, if as written, is going to raise a lot more questions then it's going to answer. And so what I am seeing, because it pretty much brings the entire declaration into a piece of Canadian legislation, and the two were never meant to be complementary. Do you know what I mean? It was never drafted as a piece of Canadian legislation, so it doesn't fit well as a declaration into Canadian law. And there hasn't been any work really to remediate a lot of that. And so some of the, to get to some specifics, of course, we all want affirmation of Indigenous rights. And I think everyone in principle agrees with UNDRIP. But what does C-15 do wrong? First of all, it doesn't say if it's an immediate application or if this is a process. It's not clear in the legislation if the day it's adopted, if all the laws in Canada have to retroactively go back and meet UNDRIP and who decides and that kind of thing, or if it's a process, if this is something that the action plan is going to do instead. That's not clear. It talks about having UNDRIP having force in Canadian law. It doesn't say federal law, it says Canadian law. And does that mean that the provinces and the territories and municipalities and other, what is the extent of that? They haven't defined that. There isn't a definition, and Melissa alluded to this, of what is consent. And the minister has said many times that it's not a veto. And so that's helpful, but they've failed to define it in the legislation. And to get to the end of it, people have different expectations from this bill. That is absolutely clear. There's different expectations of Bill 41, which is what BC passed, and there's different expectations about what Bill C-15 means. If everyone has a different interpretation, that means that at the end of the day, it's going to have to go to a court. A judge is going to decide what our legislators have failed to implement into this bill. And so for me, it's an abdication of their duty. As legislators, they should be making legislation that we all understand what changes the day that C-15 passes. No one understands right now what will change the day C-15 passes.
Thanks, Heather. My personal bias on this is quite strong in the sense that I always think that if this is really going to be a turning point, kind of going back to what Melissa said, this is going to be a turning point in the way Indigenous and non-Indigenous people are rated in this country. It should be a matter for great celebration. It shouldn't be something sort of rushed through the House of Commons and rushed through the Senate and brought in sort of toward the end of a parliamentary session. This should be something that all Canadians should actually be embracing as a meaningful and significant change in the way Canada is going to operate. It isn't a piece of government legislation. There should be a piece of sort of national unity that actually provides a new future for all Canadians, as Chris was mentioning. And as you point out, Heather, there are some fundamental flaws in the way it's done at this point, in the way it's drafted so far. So I'm going to go through the three of you again on a different sort of question, if you don't mind. And we had several Indigenous leaders, other than Chris and Melissa here, who were going to join us. And these are people who've actually spoken up publicly about their concerns about Bill C-15. And these are very, very busy folks, and they just weren't unfortunately able to join us today. But all of us know Indigenous leaders and communities that are critical of Bill C-15. So this is not us as analysts or commentators, but these are community leaders and communities themselves. What are they concerned about? What's making them upset? And to put this in a different context, this is my own bugbear about UNDRIP, is that when people talk about UNDRIP, they immediately come to free, prior, informed consent, and they immediately think the only issue at hand is resource development. And I'm with Chris on this. I think it's a huge issue, although I think Indigenous people already have, under duty to consult and accommodate, many of the same sort of opportunities and regulations. But actually, UNDRIP actually talks about the fact that the federal government has to consult with Aboriginal people on all legislation that's going to affect Indigenous people. And so the interesting question that pops up, does UNDRIP actually meet the threshold? Does Bill C-15 meet the threshold of UNDRIP? Have we had free, prior, and informed consent about UNDRIP, which is the ultimate statement of policy on behalf of Indigenous people and designed to sort of strengthen their rights and cause? So we're going to go through our group one more time. Chris, what do you think about that? Why are communities and Indigenous leaders upset with Bill C-15? What's the nature of their criticism? And does this meet the UNDRIP threshold?
Well, it's a great question, and it's continuing to come up. Well, they didn't write with the actual rightful title holders. I mean, let's be frank about it. The reason why Indigenous leaders are upset in Canada about this bill is because the federal government continued to meet with urban organizations such as UBCIC and regional representatives I've heard it over and over again, Ken. The frustration part for so many of these communities that produce a good piece of the revenue in our province, that produce jobs and economic opportunities, were never consulted on this. It wasn't until later they started to pay attention that they should be speaking to some prominent leaders that are out there here on the coast and in inland. But they're frustrated because these are other Indigenous representatives that are at the table talking with the federal government. They're speaking about policy development and this implementation of this bill, and they're speaking on our behalf. And at the same time, they're trying to incorporate this hereditary process. They're trying to enforce that. And I don't care who you are. If you don't understand the internal workings of a community when it comes to hereditary versus the elected body, if you don't understand the challenges they are facing internally, you are going to have a heck of a time aligning those two bodies. I've always said this, that the only way Indigenous people are going to be able to overcome those challenges is the internal workings themselves. When you start to have third parties, whether it's government or NGOs, try to interfere in that process, it's never going to work, because you just don't understand the dynamics and the challenges. And let's be frank about this. There's been a lot of disagreements within our communities when it comes to hereditary and the elected body. So going back again, as an elected body, when I once was, my job was to hold land in trust for the people of our community. Now, everybody wants their hereditary system to be in a working, to be working so that we could work coincide, we could coexist as two bodies. And I've always recognized that there should be an opportunity for the hereditary body to come together like the Senate, so that they could feel like they're a part of the process, meaningfully giving back to the community, providing advice from a culture perspective. But at the same time, we cannot forget about what today's world and things are moving and how quick technology and innovation is evolving. I think if we could combine those two, we could make for a very good opportunity for our people. But going to metropolitan organizations and going regionally and only connecting with individuals not from our territory, it's going to make for a lot of pushback. I just think that the federal government is going to be in for an uphill battle as this progresses. And so my question to that is, if this fails, which I hope it doesn't, if things don't go the way they say they're going to go, making their commitment to us as Indigenous people of Canada, who's going to be held accountable for that? Is it the lawyers and consultants that made their recommendation to the federal and provincial governments on this? Who's going to be held accountable? Are we just going to go around in circle again? Is a community going to be fighting just to start bringing opportunity to their communities, to bring wealth to their communities? If that doesn't happen, who's held accountable? Because I want to know. I want to know who's going to be responsible for, at the end of the day, if they don't fulfill their mandate to us, who do I get to go to hold them accountable? Who can I go to within my governing body to make sure they're aware that whoever worked on this bill and they didn't live up to it, who's going to be held accountable? Is it going to be back on us again? Promises to break promises? Because I tell you, there's a lot of people that are not really paying attention because it's not resonated with them yet. But those that are paying attention, the ones that are going to be responsible to govern their communities, they're the ones this is going to fall back on if this isn't met.
So, Chris, that sounded suspiciously like a campaign speech for the next federal election. So we'll sort of leave that to the side. But your point about accountability is a really important one, because this does raise it. And I think Heather and Melissa both mentioned this. This document raises expectations. You can't bring in something like UNDRIP and says this now applies to Canadian law without Indigenous people expecting not small and incremental change, but transformational change. And it's not quite clear when that's going to come, how it's going to come, who's going to do it, and like you say, who's accountable if it doesn't happen. Thanks, Chris. Melissa, over to you for your thoughts about the Indigenous communities and their criticisms of Bill C-15.
One of the things that I've been hearing the most of is this bill doesn't address the issues that we have in our communities. What happened to the boil water advisories? Why was that pushed back another 5 years? So with the implementation of this bill, can we go back to that and say, okay, you pushed it back 5 years, but no, we want this done tomorrow. We want our communities to have clean drinking water. It's not addressing issues like suicides on the reserve. It's not addressing issues with policing. It's not addressing the issues that we are dealing with today. Yeah, there's some very good initiatives in there, but it's not addressing the fundamental human rights, which is what this bill is all about. And at the end of the day, leaders are questioning who, like Chris had said, who's going to be the one to make decisions. Or is the decision making going to be taken away from them? Is it going to be given to another group? Is it going to be given to an organization? Like, who's going to come in and speak for these communities? And taking that right away from our elected leaders, it's frustrating because they're the ones that are on the front lines. They're the ones dealing with the community issues. They're the ones dealing with the people. So they're frustrated. They don't know where this bill is going. They said there's a lot of nice things in there, but it's just not addressing today's issues that we have.
Thanks, Melissa. That's a really excellent point. Heather, to you, about Indigenous communities and their criticism of Bill C-15.
Yeah, so you alluded to the fact, Ken, Article 19 of the Declaration specifically states that states shall consult with Indigenous peoples through their own representative institutions in order to obtain their free, prior, and informed consent before adopting and implementing legislative or administrative measures that may affect them. There is no legislative measure that more affects Indigenous peoples than C-15, which is about their Declaration on the Rights of Indigenous Peoples. So what people may not know, or hasn't been covered in the mainstream media very well, is that there are dozens, maybe more, maybe hundreds of First Nations that are opposed to C-15, that have not given their consent for C-15. And some have been very public, like Treaty 6, Treaty 7, Treaty 8, which represent dozens of First Nations, mostly in Alberta. But there have been individual First Nations that have also submitted letters in private and public. You can go to the INAN committee, the House committee website, and see all the briefs that have been submitted. Some First Nations have indicated they would support, but only with amendments. Those amendments have not come out. So what I want to say is that if C-15 was a pipeline, it would not get regulatory approval. It would not have met the standards that the federal government has not achieved the consent with everyone affected that we expect resource companies to achieve. So it's ironic and in some ways laughable but terrible that this bill is going through this way. Now they did consult very heavily with the AFN, the Métis Nation, and Inuit, the ITK. I don't want to get the Inuit Tapiri Kanatami. Anyway, so they did consult with those, and there is a sense, I think, in Ottawa that is good enough. And I don't know that the average Canadian appreciates the extent towards there is division between First Nations and the AFN at this time. And Perry Bellegarde did testify in the House and was asked that question. Does he have a mandate from his First Nations to go and to say that we need to pass C-15? And he said he got his mandate in December, I think, in 2019 for Bill 262. And that mandate holds up today for C-15. And I think many, many First Nations disagree with that and have publicly stated so. And so that's where we can't play both sides. Either you need free, prior, and informed consent, either you need to consult meaningfully, or you don't. And why this would be the exception to the rule, I do not understand.
It's clear what you think, Heather. This is excellent and really sad commentary, because again, we're losing the chance to celebrate something. And I feel really badly, to be honest. I'm sure we all do, that we're criticizing something that at its root has this declaration that is celebrating something we all agree with so strongly. And yet we're sitting here thinking, well, why are we being so critical? And yet I think there's some very good reasons. Melissa, I have a particular question for you, if you don't mind. At the community level, how much conversation is actually going on about UNDRIP? I mean, is this something that people are sitting in the bingo? Well, I guess everything's closed down this year. I was going to say sitting in the bingo hall or sitting in the restaurant. I mean, are people talking about Bill C-15? Is this transformative event that people are all jazzed up and excited about? or is this something that's happening in Ottawa a long way away from home?
This is something that's happening in Ottawa a long way from home. It's something that they don't see that's going to directly impact them until a decision is made that they may not agree with. They see it as a good thing because it references these calls to action. So a lot of people are thinking, okay, once this bill is implemented, they're going to actually start work on this. They're going to start investing money into some of these initiatives. And at the end of the day, I asked them, okay, who's going to be speaking on behalf of our community? Is it our elected chief and council? Who's going to come in and make decisions for us? Because in this act, it's not clearly defined. But they're not seeing that part of it. They're seeing the nice part of it, where we have promises and people are thinking this is a great thing for us without realizing how poorly written and drafted it really is.
Thanks, Melissa. I mean, here's one of the interesting things from my perspective, I guess, is that we've actually just seen in the last federal budget the largest ever expenditure on Indigenous programs in Canadian history by quite some distance. The federal government has brought in all sorts of downstream promises to provide all sorts of funding in lots of areas, and it's kind of ironic that the money was being spent before UNDRIP was through. Because when you say, Melissa, about where's the money going to go? Well, the money's there in the sense that the federal government has spent it. So is there now going to be incremental money on top of what the federal government has just promised? That's a really interesting and important puzzle. Because, in fact, I think those two things could have been linked together. Chris, do you have any thoughts about the community interest in this document? And, you know, you're in business meetings all the time and you're in your community constantly. Are folks talking to you about Bill C-15?
Chris, you're muted.
I think somebody behind the scenes has done
There you go.
that.
There you go. Yeah, going back to it, not a lot. Not at the grassroots level. I've had community members say, "No, we got to get this bill passed." And I asked the question, "Do you understand what this means?" And 10 out of 10, they don't have a clear answer or they don't understand it. I was just with family this long weekend. I asked this question, and the response I got was, "It's not enough that's going to impact my daily life, so I don't pay attention to it." And my response to that is, well, it's going to impact you at some point. I think you should pay attention because this is huge. Look, and then there are leaders that I work closely with, and I think Ottawa is well aware who I work with in some respect, that they're just frustrated. Some of the leaders that I do communicate with, I get very good sound advice from, are extremely frustrated with this process because they have felt completely ignored. It's a bill that continues to push the hereditary status, which none of us are opposed to at all. Like, I mean, if we're going to do this, this should be left up to the governing body to do, but they continue to push this hereditary status in this bill, what has caused dissension among community members and within our governing body. And we talk about democracy and how we want to be part of this country, yet we're taking the decision-making process away from the very community, the very body we've elected in. I wanted to go back to Heather's point about the pipeline and resource development projects. We talked about how industry and government was doing this all wrong when it came to big global opportunities for our communities. We condemned them. We got upset by them that the process didn't meet our needs. Yet here is a bill that is being introduced. It's going to pass in the House that is completely undefined. It is poorly written. And I felt even to a point where it was unorganized. And yet we're the very same people condemning industry and government on a process that we felt was flawed. How could we turn around and implement a bill that has the same criticism? So if we're going to point fingers, then we better point one back at ourselves for us pushing this, for Indigenous leaders to push this through, that we're a part of this process. I mean, that doesn't make any sense to me. Now, it's not that I don't support UNDRIP. I support it. But this whole process, I feel, is completely flawed. And I really believe there's going to be insurmountable challenges ahead. I'm going to go back. It's going to be up to our elected Indigenous leaders that are going to have to carry the weight of this.
Yeah, thanks. Heather, I'm going to ask you a different question, if you don't mind. UNDRIP has been described as a promise to make promises, which is, in terms of legislation, kind of a strange thing to describe it as. What has to happen? What do you think has to happen next to make sure that UNDRIP actually serves the interests of Indigenous people and Indigenous governments in Canada? So let's just assume, as Chris just said, maybe it goes through the House, goes through the Senate, in its undigested current form. What has to happen to make this real, and real in the lives of Indigenous governments and Indigenous peoples?
Yeah. So one positive thing I can say about C-15 that I agree about is that it puts forward that we need to have an action plan. I don't think we need legislation to have an action plan. We could have been working on the action plan, for the last 14 years. So I feel like this has been delaying that, for one thing. And I think New Zealand's process, and we often, looking at our comparators, New Zealand is one of the few that maybe does it, even better than Canada, or does more. They led with an action plan too. So having an action plan to go through this and be concrete and consult properly about what is the action that needs to happen. And I think someone has said, right now it's a symbolic gesture. We're all going to pat ourselves on the back, and the Liberals and people in Ottawa will say, we did good. We put this through. But what is the action? And so I can't wait till we get to that action plan. And like I said, we could have been doing that for years already. I think it can be good as a standard. And the TRC, the Truth and Reconciliation Commission, calls for action has been useful in that respect too, to say, here is the standard. So when we say, here's Article 31, are we doing what Article 31 says? What are the gaps? What have we been missing? What do we need to change so that we, accomplish some of those things? So I think it is helpful providing a standard and having a process where government and an annual report must be held accountable for that standard. But we could be doing all those things right now. We do not need C-15 to do those things. And C-15 has a lot of unintended consequences for Canada. And I'm sure Ken will get to the resource development question soon also.
Super. Thanks, Heather. Melissa, what are your thoughts? What has to happen next to make this real? Make it substantial for Indigenous peoples and communities?
One of the things that needs to happen is that we need to piece out this bill, because if we're going to challenge it, we're not challenging it in its entirety. We need to challenge certain sections of it. And this is why I bring up the fact that it was poorly written, because if you're okay with the first 5 sections, but maybe it's 6 and 7 that refer more to land, for example, or consultation, then those are specific areas that we can challenge in court, or that we can challenge with the bill. We need to have, once again, I said this before, we need to have clear definitions of who is Indigenous. Am I Indigenous? Do I fall into this bill? Because I don't know if I do. It does not reference the treaty, the Indian Act in there. It does not reference, it makes reference to some treaty rights, but I don't know if that encompasses me as a person, and if I fall under this bill, or if it's just organizations that fall into UNDRIP. So, or Bill C-15, sorry. So I think we definitely need to go back and amend it, clean it up a little bit, and just make it useful, so that it's useful for Indigenous and non-Indigenous people. And that if we're challenging it, we're not challenging the entire bill. We might be challenging certain sections of it. So I definitely think it needs a rewrite.
Thank you very much. Appreciate that. Chris, last thoughts on this question to you?
Well, I think they got to go back and meet with the rightful title holders. Right now, as it stands, it's the governing body that holds in trust so many of these topics that they represent us for. That's what they're there for. There is no mechanism in place for the hereditary system to be incorporated this time. In the bill, they're describing it as a nation-to-nation process. Well, what is that? What is the nation-to-nation process? That needs to be clearly defined, and I just think there's going to be a lot of work, but that won't happen until the federal government goes back to the rightful title holders. I've always said this, and I will continue to say this until there's something different that actually has meaningful change, that's going to actually change the process for the greater good of the community. You have to have the elected body that was elected in by the people to help deal with this process, because they're the ones that hold our land in question. until we could get our hereditary body in order, that's going to be really hard to do. If you're talking nation to nation, which I've heard people speak at conferences that, we want to incorporate hereditary, we want to have that nation to nation building, but what does that process look like? And right now, that's super unclear to me, because I still feel it undermines the elected body. If that's the case, why are we continuing to elect our governing body? I mean, that's who we are as Indigenous people. I know people want to get to a sovereign position so we can manage wealth. Someone's got to make a decision, and we got to get there somehow. And right now, it's the elected body.
Thanks, Chris. Folks, this has been terrific as a sort of a warm-up for the second act, and the second act is drawing on the quick questions and wisdom of our audience. And so I'm going to go through a series of questions that are coming to us. I'm going to address them to each person in turn, if you don't mind. But of course, if I ask Chris a question, Melissa and Heather, you feel free to answer back, and vice versa. So we're not trying to sort of stop any conversation. Just want to get through as many questions as possible. But as are the British Columbian on the panel, or the person in British Columbia on the panel, I'll ask Chris this question. Sana asked basically, what are your thoughts about British Columbia's passage of UNDRIP? We have some experience with UNDRIP coming into provincial legislation. So what lessons can be learned from how BC handled it?
Well, I think BC was a bit premature on pushing UNDRIP. That's just my opinion and my conversations with leaders. If you take a look at from an economic perspective, many projects were canceled, not just at the BC. Well, I should say the BC level was trying to find ways to see whether or not Trans Mountain or LNG Canada should go forward. But what ended up happening was, with this piece of legislation being implemented, there was all this talk about there was a flawed process, so let's try to stop these projects. But what evidently, I feel anyway, what has happened is that the BC government has painted themselves in a corner. And I think that lessons learned from this, I think that they need to go back again to speak with the rightful title holders to make sure that the mistake won't be made again. Because I tell you, there was a lot of criticism of the first go around from the BC level simply because it was rushed.
Okay. So thanks, Chris. Let's turn, Heather, to you on the question of a veto. And let's focus specifically on the matter you brought up, this issue of resource rights. And to very many Canadians, I'm always surprised at, and I'm sure this doesn't apply to the audience we have today, but very many people talk about UNDRIP without having read it. And if you look at UNDRIP, it talks about education, it talks about health, it talks about family law, it talks about a whole range of things. But if you ask the general public, UNDRIP is about resource rights, and it's about the free, prior, and informed consent over resource development. So the question to you, Heather, is does UNDRIP convey a veto to Aboriginal people? And I guess the sort of Andrew asked a question about this in the same way, that is there a way of convincing Indigenous groups that UNDRIP does not mean an absolute veto? And it seems, this is Andrew's comment here, there be expectations being created that are not based on fact and law. So what are the consequences of UNDRIP as a veto or non-veto over resource rights? Heather?
Great. I feel like this is such a poorly served question, that there's so little nuance about this question. There just isn't a way in a Canadian sovereign state that 670 or 630 First Nations could all have a veto over anything. But yes, some things they could have a veto over. And so what you can't just say they'll have a veto over everything or they won't have a veto over anything. The question for C15 is, what is consent if denial of consent isn't a veto? And I think what will actually have to happen, and this will just delay the process, is that it'll be a spectrum. I think, and it's if a community was to be relocated, they would have a veto over that. I think we can all agree that that's good, that they should have a veto over relocation. Or, for example, hosting nuclear waste on Indigenous territory. That's probably something that they're entitled to have a veto over. There are definitely some things that Indigenous communities should have and do have a veto over, I think, and would never happen without their consent. Are there other things that probably is not reasonable? I think from a legal perspective, reasonable to provide a veto. If there's a highway and there wants to be some work done on that highway, is there a right to veto that work? Probably not. That's probably not reasonable, for example. And I think over the course of jurisprudence, it probably wouldn't find that, and that wouldn't be the case today. So TMX, for example, is the most recent, decision pre C-15, but it did show, there is accommodation and it is reasonable. There has been, consultation. There have been accommodation. There has been mitigation of any harms to Aboriginal rights that the state can to make that decision to go ahead with something. I think that's probably what's going to go ahead. And for the record, I don't think the 634 First Nations want 633 of the First Nations to be able to tell them what they can and can't do, if there is a linear project. So I don't think that all the 100 communities on TMX want the 4 that don't want it to be able to have a veto over what happens, to their livelihoods too. So it's about a balancing of rights. And I think we've been looking at it in this very black and white lens that either there's a veto or there's no veto under any circumstances. And I think the answer is going to be gray in the middle. And that's the conversation we need to have. What is the gray in the middle? What are the circumstances under which they do get a veto? And what are the circumstances under which a veto would not be reasonable? And let's be adults. And, instead of, the minister saying it's not a veto, in his speeches, but not in the legislation, that's not going to help us in the end of the day.
Thanks. Chris, do you want to comment on this as well? And then you, Melissa? This is a pretty important issue here.
I mean, Heather's right. I mean, her analogy of it all is correct. I look, at the end of the day, we can't have a select few have a veto over a mass population and wants to see resource development happen, whatever that may look like for that said nation. And I'm going back, my concern has always been with this process. One of the things I've noticed is these NGOs have really clung on to this UNDRIP bill. So much so they came out and started speaking for communities regarding Bill C-15, and they were trying to push a veto. And I'm glad there's not, because we would never see any projects. But I have to agree with Heather. We can't be saying one thing and doing another. There's a thing called democracy, and we talk about how we want to be a sovereign nation. Well, you're never going to get 100% in favor of anything. But there are things that there can be a veto on, making sure that we take care of our children and families, making sure that our environment isn't going to be flooded with toxins or harmful activity. I mean, nobody wants to create opportunity while we're destroying the environment. I've never met a single person out there that has ever said they wanted to destroy the environment on behalf of development. So when we come to this bill, the first thing that always comes to mind is making sure we build a sovereign wealth opportunity to bring our communities up to the playing field where we, again, I'll keep saying it, so where we could be a part of Canada's economic engine to bring our people out of poverty and start managing wealth.
Thanks very much, Chris. Melissa, your thoughts on this one?
Bill is being used as, because the whole point of this bill is to get out there and consult with communities. Consultation doesn't mean that they're going to agree with you 100% of the time. It could be certain communities are in favor of it and certain communities won't be, but that doesn't mean the project can't go forward or projects can't move forward. So we're viewing this as a yes/no, and really it should be we're addressing the issues, we're looking at them, and can we come to a compromise somewhere? And I think that's what we really need to focus on versus who gets to veto what. And if we can't clearly define this in this act, it's going to cause chaos amongst communities. And it's already causing chaos amongst communities because not everyone has a hereditary system. I'm from Saskatchewan. This is the first time I've kind of heard about it. This is not something that we normally deal with. So a hereditary system might work for a community in BC, but it's not going to necessarily work for a community in Saskatchewan or Alberta or Manitoba. So we can't be making general rules for everyone to follow when we're diverse like Canada. Each province has its own diversity, and we need to start seeing Indigenous communities the same way. We're not all the same. We don't have all the same resources. Some of us are so far north, we have nothing. So we need to start looking at individual communities and what their needs are. And this bill doesn't do that because it's pushing us into a big melting pot and expecting us to make decisions together 100% when that's never going to happen.
Yeah. Thanks, Melissa. Excellent. So Gail asked a question, and I'll read it here. I thought the bill mostly just creates a framework for developing an action plan. What do you think? What do you think of the action plan process described in the bill? So Heather, you talked about this a bit before in one of your comments. So I'll ask you to respond to Gail's question.
So it describes creating a framework, but it isn't clear whether the bill again has immediate application, or if it only has application as the framework moves along. That is something that could easily be addressed in an amendment to make clear if it's the government's intention that the framework is to develop an action plan and start implementing over time. That would, probably assuage a lot of the concerns, that the government has not done that. So one thing is we don't know that it's just creating a framework for future, implementation. For some, they're interpreting it and has been interpreted in BC courts, or the argument has been proposed that it's immediate application. So that should be a warning sign to the federal government. So what do I think of the action plan process described in the bill? It's very light on the process, and that's been a big criticism of it. Of the time frame and the process. Who's going to be consulted? Are they going to finally consult, as you would if you were going to do a resource project in a meaningful way? So that's not clear, but I will say I was glad to see that they finally allocated some money in this latest budget. And so at least there's money there. And I'm sure there's people busy in Ottawa who are deciding what it, but again, it's very opaque. It's not clear. Communities haven't consulted, I don't know, on the action plan, because no one has heard what is the action plan. And so that's obviously a problem too. I have some sympathy for that, because, to have to consult, 700 rights holders about an action plan process, that's also tough. And, and I think New Zealand, I mentioned that they've taken the action plan process. I don't think it's been easy. I think, even the process that they have taken, even though it wasn't legislatively driven, has not been easy either. But I guess we have to stop being so afraid of these difficult questions of the hereditary chiefs issue, of representation, of what is consent, of what do you get, consent over. We have to start having these conversations, and I hope an action plan at least provides that instead of just tiptoeing around all of it.
Thanks, Heather. Chris, I'm going to put the question a little bit differently to give you a chance to respond to Heather as well. Mike asked a question. There are 634 First Nations in Canada. There are Métis and Inuit that are also included in the UN Declaration about Indigenous people as well. How do you suggest that all can be heard and their concerns addressed in order to reach any kind of an agreement? So in other words, the action plan, consultation, how do you actually do this? How do you do this on a national scale with so much diversity among the First Nations, the Inuit and the Métis?
Well, I think they should have approached this. Look, first and foremost, everyone knew this wasn't going to be easy. But again, I keep going back to the representative bodies that are the rightful are the rightful holders of the land. I really think they should have gone back to have these consultation processes with the communities across the country. You could have did it, like, for example, the North Coast sit down amongst each other. For example, we had started the Sibshean Roundtable here in the Prince Rupert area, and all 7 leaders are participating. We could have had these discussions at this table to talk about what would work and what won't work. And as simultaneously, they could have went across the country. But again, I mentioned this a few times now. I feel like this is more of a political push than anything in this particular stage. The Prime Minister talked about a great reset here, something that completely surprised so many people. Well, the Great Reset should have included this process around the consultation to accommodate the First Nation people that they're going to be responsible to hold this bill up. I really think they should have done that simultaneously, and they should have took their time when you take a look at the time frame that they're pushing this through, it's not very long. I mean, we've been at this for over 150 years, and they're managing to pull off this bill in a couple of years. I think there should have been more time and more thought put into the process to start speaking to key leaders here on the coast and throughout this country to properly sit down. And that process should have been scheduled out across the country with all the impacted communities. That would take a few years to do.
Thanks very much. Melissa, what are your thoughts on this question? How do you consult with so many people, so many cultures, so many language groups? How do you do this properly and effectively?
I'm going to have to agree with Chris on this one, because they should have started at the community level. Why didn't they start at the community level? Because that's where you're going to get your answers to what's needed in those communities. They're going to tell you exactly what they need. The leaders know what is needed. Sometimes it's different, sometimes it's the same as your neighboring community, but they understand the challenges, and it really should have started at the reserve level and ventured up if needed be. But now what we're trying to do is we're trying to create this bill that encompasses everyone, and it's not working. And the whole point of this bill is to have it work for Indigenous people. And we need to go back, and do we need to start over? Like, do we need to start with the consultation of these communities first to actually draft something that's going to work for our people? I think they did it backwards. Like, they started at the top, and they're expecting that top to trickle down evenly to each of these communities, and it's not going to happen that way.
That's a very, very useful perspective and a very important sort of observation. So let's shift a little bit from legislation and the parliamentary process to good old-fashioned partisan politics. This is being brought in by a liberal party government in a minority situation in the lead up to an election. So there's a whole bunch of factors that sort of come in there. So I'm going to ask a question that Nick asked. How do Canadians across the political spectrum talk about the issues of C-15 and UNDRIP without it creating animosity? You have an NDP party, Conservative Party, Bloc Québécois Party, other Green parties, Liberal Party, obviously. How do you have in a partisan political environment a constructive discussion and debate without it becoming a part of the problem and making things worse? So, Chris, I'll give you the first shot at that.
Look, I've always said that nobody's free of criticism, including myself. I think from my perspective and what I've noticed over these last few years, we've lost the art of critical thinking, and everybody's so afraid to give their opinion on any issue, in particular Indigenous issues. As a Canadian, I don't think you should be afraid to voice your concern if you have a concern of any bill, whether it's Indigenous or not. I think you should come and speak to leaders, speak to Indigenous people, ask them how they feel about this bill. You're going to get an honest answer. Some are for it as is, and many are not. But I think one of the things I've noticed in this country right now is we've lost the art of actually having a conversation without screaming at one another. And that's got to stop. I don't know how it's going to stop. I wish I had a magic wand, but I think as a Canadian that is living in this country has a right to express their views on this bill. We could do that in a constructive manner. We could do it respectfully. The one thing I really disagree with, when somebody disagrees with an Indigenous issue or that of a person of color, it automatically they're labeled as a bigot or a racist or some sort of person that's going to do harm. And that shouldn't be. I mean, Canada is a diverse country, and yes, look, I'll be the first to stand up for Indigenous affairs and issues, but I have many friends that are conservative. I have many friends that are liberal. I have many friends that are NDP. I have many friends that are Green. We have had these tough discussions. We have sat across from one another where they gave me their views. I didn't come out screaming at them and say, well, if you're not with us, you're against us. And it's about this Bill C-50, and it's about Bill C-69. It's about our inherent right. And then I mean, my best friend is non-Indigenous, and we have this discussion. And he said to me one time that he was afraid to talk about indigenous issues because he was afraid of being called a racist. And that's wrong. I mean, if we're going to move forward in this country, we should have the ability to be constructive without screaming at one another, without insulting one another, and being respectful and understanding somebody's view. It doesn't mean someone is racist against you. All they're expressing is their view on the issue of the bill. It's not you as the person they're addressing. And if somebody's going to address you as the person, well, then that person should never be having the discussion. You just ignore that individual if they're going to start using race as the factor of the discussion. In my perspective, and when I've had this discussion from people from all walks of life, we've had constructive conversations. We've had disagreements. And that's where I feel critical thinking right now has kind of gone out the window because people are fearful of talking about Bill C-15 just as they are of other issues. And we got to get away from that. There's nothing wrong with having constructive debates.
Well, I would say even more importantly, it's vital that we have constructive debates. Chris, I couldn't agree with you more. Melissa, what are your thoughts on this? I mean, can something like Bill C-15 make it through the partisan wars, through the political parties and electoral processes in Canada?
I think the way it's written, you're either for it or against it. It's not written in such a way that you can challenge certain sections of it. And when you do challenge it, you're seen as racist. Even as an Indigenous woman, there is a lot that I challenged within this bill, and I was seen as racist. I'm like, well, how could that be? Like, I'm challenging certain aspects of it. I'm not challenging the entire thing. So we need to really get out of that mentality of, if you're challenging an Indigenous issue, it means that you're now a racist person. We need to step back and say, no, that's no longer the discussion that we're going to have. The discussions that we're going to have going forward is, how can we make this better for everyone? How can we make this better for the Indigenous communities? How can we implement certain things that I think would make this more productive? So we need to get out of those siloed conversations, because this is not about race. This is not about Indigenous. This is about helping communities. This is about incorporating these communities into Canada so that we are part of the economy. We are part of big decisions that are coming down. We're part of legislation. We need to start removing ourselves from these silos, because it's no longer, if we want to move forward and we truly want to reconcile, it can't be about race anymore. It has to be what's in the best interest of people.
Thanks, Melissa. I appreciate that. Heather, what do you think? Partisan politics going to kill Bill C-15, make it better, create dissension within the country? You know, can we have the kind of debate that Chris is talking about, an open, honest, fair debate about Indigenous affairs?
I hope you can indulge me with a bit of a long-winded answer, but I promise I'll get to the point. We haven't discussed yet what the consequences of C-15 as written are today. And it is reducing the competitiveness and deterring investment in Canada in our resource development, because it is not clear how and when you can get resource projects done and approved. So investors are looking at Canada and saying, it's a crapshoot. You don't know when you're going to get approval. You don't know if that approval will be rescinded. You don't know if there'll be blockades and protests. You don't know if the contracts will be enforced. And Canada has fallen from the Ease of Doing Business Index, I think, from about 4th in 2006 to, I think, 20 something right now. So that is, when people are concerned about C-15, about how it's poorly written, the concern is that investors are going to say, we don't know how to get approvals. We don't know what the process is. We don't know what consent means. We don't know who can provide consent. And we don't know if that consent will last with the whole project. That is the implication. Tens of billions of dollars of investment, and that's not hypothetical. It's already been lost. Canada has been losing that level, that scale of investment for the last 20 years. And so the Conservatives are opposed to that. And this is the problem with our country, is that it has become a conservative issue to protect resource development and economic development, and it has become a liberal or a left issue to protect Indigenous rights. And this is where I'll pitch my report today, but I don't think people understand to the extent that Indigenous rights and resource development are intertwined. That is where their economic self-determination comes from. That's where their best paying jobs comes from. That's where their royalties and their own source of revenues comes from. And so to break these apart is nonsensical, and that's what Canada has done, is we've separated that either you're for economic development or you're for Indigenous rights. And do people understand that Indigenous rights mean also economic rights? And that means that people have access to development and have access to jobs. So I'm very, I have a PhD in political science, but this was my first time testifying, to committee. And the Liberals just asked their Liberal witnesses the questions, and the Conservatives just asked the Conservative witnesses the questions. And there was no good faith effort, in my opinion, to improve the bill. The effort was made to win the bill. They're trying to win, that their party wins. And so it's very discouraging. Can we have an adult conversation about improving the bill and not getting rid of it and not just passing it, the way it was written on the very first day? I have a little bit of faith that the Senate might come with some constructive amendments that the Liberals might be interested in, because I think on C69 and C48, the Senate did play a role and came close, and proposed good amendments and listened. But in Canada, the Senate's not really designed to do that. It's up to the government at the time to decide if they want to listen or not. So I have a little bit of faith that the Senate might come up with some constructive amendments that everybody knows we need. We're talking about, changing 200 words would save tens of billions of dollars in investment, which would create thousands of jobs in this country. And they don't seem willing to do it.
So a partisan issue for sure. Go ahead, Chris. You got an
Yeah,
observation?
look, I'm glad you brought that up, Heather, because as you know, we're dealing with this every day. The certainty for investment for Canada has really flew the coop. I talked to a lot of big businesses, both international, both here in Canada and United States. They're really, really afraid to invest in Canada. We've gotten a few, very little, across the finish line. Like, when you're looking at TMX and you're looking at LNG Canada. But when you look at the growth in the oil and gas sector, United States grew significantly. I think it was over 50%. We only grew by 2%. And yet we continue to import resources into Canada, and yet we have all of this rich resource at home. When I look at this bill, I look at it as a lens of what they've done with our resource sector. They were so bent on pushing this bill forward, they forgot about all those little things that are going to make it work. They forgot about the 634 communities that are going to be impacted, which is going to impact all Canadians. So it's extremely frustrating for me. It's I really think that we have a good group of people out there that are trying to do the right thing. It's no different with the people that are wanting to implement this bill, which is going to pass. But you can't have a sovereign nation without generating wealth and revenue, sole source revenues back to our communities. And I keep going back to this. Indigenous people, forever and a day, since time immemorial, have never relied on a government system. The system was introduced to us. So what did we do? We were independent. We created our own wealth. We created our own way to take care of ourselves, free of independence from any sort of policy or legislation. We bartered in trade. We did what we did to survive, and it was independence. And I just see that the bill and what's happening in this country seems to, people want to dictate where they think investment should go, but they're failing to recognize that the oil and gas sector, the resource sector in general, is all in the Indigenous backyards that can contribute to this country, that can give revenues back to the system to help pay for services. They're failing to recognize that. And this narrative out there that somehow that we're going to abolish oil today, we're going to abolish gas, and somehow wind and solar are going to power up the national grid. That's just not realistic. Now, it can be an opportunity to play a part in resource development so we could get to net zero. Can we reduce our GHG? In this bill, will it address that? Will it start to attract the investment back to Canada? Because right now, I don't know if it does. I know when speaking to industry that they really want to come back to Canada. And there's a lot of certainty that there's going to be required for them to come back to Canada. So the government's got to understand and play ball that investment is going to go where it's required to go. Investment's going to go where it's going to attract the money. And so we need to understand it and get away from this narrative that somehow oil and gas is bad or resource sector is bad, cutting down trees is bad. fish farming is bad. The narrative out there is lost. And again, I go back to critical thinking. I really think this bill is lacking a lot of it.
And
Thanks. Well, go ahead, Heather. Jump in.
If I can just quickly jump in there, because I think a lot of people are against oil and gas, and that's one thing. But if we need to transform into a green energy system, we need way more transmission lines, we need way more hydro, we would need way more mining for the batteries and the solar panels and the windmills. And under our current regulatory system, we cannot get any of that built in Canada. So if it is your desire to see a green infrastructure revolution, this bill is not going to help that succeed either.
It's interesting, because one of the flip side of the veto debate, which is we've had a good discussion of that. I'm sure we can continue for a long time about it. Is it a veto? Is it not a veto? Is I hear a lot of First Nations leaders tell me repeatedly, actually, if we have a veto over a project, it means we also have the right to say yes. And if we say yes, then we want the government to back off. If a First Nation has said we want this project, whether it's a transmission line or a hydro thing, and it meets environmental regulations and standards, that the First Nations have the right to say yes to a project. It can't just be a negative thing. And Chris has described this very, very well, that, you actually have the opportunity to sort of make the kind of progress that you want to have in your own communities. And it's important for us all to recognize that there are lots of good examples in this country. Whether it's in northern Quebec with the James Bay Cree and the Inuit, whether it's the Tahltan just north of you, Chris, up in the northwest British Columbia, the groups in the Yukon that have made some very good collaborations and partnerships with mining companies. We've been able to get to yes more often than we think. But the problem is where people are stopping, no longer asking a question. They're not giving us the chance to say yes because they pulled their funding out. But you both, all three of you, have raised in different ways this sort of the international sort of aspect of this. So, Melissa, I'm going to come to you with the first question here. Diane asked us, and this is a global question. The United Nations has become involved in Canadian politics at an alarming and increasing level. Do you see this as a problem for Canada? So United Nations Declaration on the Rights of Indigenous People is a work of a global governance institution. Do you see United Nations as being a problem in Canadian affairs? We're just trying to turn, there you go.
Okay.
Thanks, Melissa.
This is definitely a problem because how does a global organization understand what's happening on a reserve? Have they ever been to a reserve? Have they ever stepped foot in a community and asked these people, what do you need? So to have somebody on a global level say, I know what is right for these people, you're starting off on the wrong foot. Like that's not the way you start off a conversation. And implementing bills without even discussing it with us, you're backtracking already. When you could have just gone to these communities, you could have spoken to leaders, you could have talked to chief and councils, you could have gotten a variety of views on what needs to happen before coming to us and saying, this is exactly what you need. This is exactly what Canada needs, without really understanding our relationship with Canada and kind of how we've come to this place. In not even understanding like some of the issues that brought us to this place. So for a global organization to say, I know exactly what you people need, is very disrespectful. It's very disrespectful to those of us who lived in these communities. It's disrespectful to those who currently live in these communities. It's not a good way to start a reconciliation conversation by telling us what to do and telling us how to do it and further legislating how we're going to do that. So it's very dangerous in that fact because it doesn't open those discussions. Because now when this bill is implemented, what's going to happen? Who's going to moderate this? Who's going to be responsible for those relationships? It's actually going to push us further apart than it is going to bring us together. There are a lot of really good initiatives in this bill, but they could have been pieced out into their own separate bills. Why wasn't that an option? Why did we need to have this global organization come in and tell us how to do things? So that's where I sit with it. And that's where a lot of my community members sit with it, because their voices haven't been heard and their concerns haven't been heard. And we need to go back and maybe revisit that and maybe start including communities in these discussions.
Excellent, excellent, Melissa. Heather, you're the PhD in political science and all this kind of stuff. So, and you've spent a lot of time working on circumpolar affairs. What's your thought about the value added from UNDRIP, and if we're not from UNDRIP, from the United Nations in getting involved in Canadian affairs? We've seen this happen many times in the past. Different UN organizations have come up and been sharply critical of Canada. And we're not quite as sharp in spitting back at them as Australia can be. So when the United Nations criticizes Australia, the government of Australia tends to bite back pretty strongly. What's your thought about the United Nations and its role in Canadian affairs?
Yeah, I'm familiar with Chris and Melissa's opinions, and I probably come a little bit soft on it, only because I see that the United Nations doesn't have power or authority over Canada. So I can certainly understand the frustration when, the UN Committee on the Elimination of Racism and Discrimination says, we demand that you halt TMX and Site C. And I think it's preposterous that they did that. And they obviously didn't consult, with anyone on the ground. So I think they do some, things that I think are ill-informed, but I think they're largely harmless because at the end of the day, they don't have power. Now it's different. The Canadian Parliament decides that they want to take a UN declaration and put it, the entire thing into Canadian law. I think that's a poor decision on the Canadian Parliament's side. Because it doesn't fit very well with our legal system. But that wasn't the UN pushing that, I guess. So I guess I'm not as concerned because I don't see that they have that much authority over Canada. But yes, I can see why their influence over the discourse can be frustrating for a lot of people.
Yeah, thanks. Chris, you want to say something?
I do. I get both views. I really respect my colleagues and what they're saying, but my perspective is this: is when the United Nations stepped in to claim that communities weren't consulted on CGL and the LNG project and TMX, they completely got the wrong information, for one. But what that message did from that level was amplify around the world that we were not consulted, that we were not involved in the process to get to free, prior, informed consent. That's the damage that message did to the rest of the world. And that's what frustrates me about this current system right now. And I don't agree with the UN stepping in at all. I mean, if they want to be supportive of the bill, fantastic, great. Let us go on with it. If you weren't going to go to the rightful title holders, well, let's get right down to business then. Because at the end of the day, what's going to make this happen is the generation of wealth, a sovereign fund or economic activity. If we're truly going to get away and be independent from the reliance on government dollars, then let us get down to business. But don't try to dictate to Indigenous communities. Don't try to favor one group of people over the next, because all you're doing is causing dissension. And it's already happened. And if you're going to continue to consult specific Indigenous communities here on the coast, or leaders or NGOs, you better consult all of us, because I'm telling you, it's caused a lot of problems for everybody, not just those that are trying to get resource or economic development for our people. It's caused problems for those that are saying, well, we oppose, because now what's happening is a lot of this opportunity that's coming forward, some of those communities, these companies and other communities that are involved in economic development don't want to approach those communities, because we know unequivocally they're going to say no. And that's because of the involvement of these NGOs and what the United Nations have been stating in the media, when they had no idea that consultation did take place. But don't interfere in the opportunity for Indigenous communities to become sovereign, to become independent for their community, because all you're doing is stifling prosperity, and you're hurting the province, and you're hurting the country and your own people.
Thanks very much, Chris. So time for one last question before we get to some wrap-up questions. So, and I really thank the audience for sending in some terrific questions. We've got a question here that came from very different versions of it, from Stephen and from Simon. It's essentially, how do you reconcile the concept of free, prior, and informed consent with the need for certainty? It sort of overlaps a bit with the questions about investment, because if you're a company, you want to make sure you don't have to revisit an issue every 2 years or every 3 years or whatever it happens to be. So how does one using that very important concept within UNDRIP, which applies beyond the resource development field. How do you reconcile the free, prior, and informed consent thing with the need and obligation to sort of get to certainty that will allow proper development to proceed? So Heather, I'm going to let you ask that one first, and then Melissa to follow up.
I mean, it's obviously a hard question. I think, we've developed since duty to consult in 2004, 17 years of jurisprudence on that. And we were just getting it settled so that we had a good idea. Resource companies had a good idea. Investment firms had a good idea of what you needed. And now I feel like this is throwing a wrench. Like it feels like the Wild West again, that you just don't know how the courts will interpret it, or what can be challenged, or what kind of, how you can be thwarted as you're investing hundreds of millions of dollars into a project, and that's the problem. And so that's tricky. I think one thing that would help, and I think that one of the biggest challenges is with BC, because they don't have treaties in the same way, and because they do have a hereditary system. And I think what has spooked a lot of investors is obviously the CGL pipeline, because there was a pipeline that had the consent and contracts and agreements with all 20 elected chiefs and councils. And for investors, I know, like the Alberta Pension Plan invested in it, they thought it was the gold standard. They thought, here is the pipeline that First Nations are behind, that we can invest in. It's a win-win for everybody. And then, of course, it was blown up. And so that is the kind of thing where we need to have the conversation and develop, and not just put the word free, prior, and informed consent into a piece of Canadian legislation and then decide not to define it because you don't want to upset anyone on the right or the left, and you'd rather just leave it ambiguous and not have to deal with the hard questions. So the way we're going about it is wrong, but there's probably lots of interpretations of how we could go about it right.
Thanks, Heather. Melissa, last thoughts to you on this one?
In consent and consultation is already happening. This is already in our regulations, like whether you're an operator, whether you're a First Nations community, this is already in place. It's happening. What we're seeing are groups, activists outside of First Nations communities that are pushing for this consent. That's why this bill is very vague, because it doesn't specify who's going to be able to speak on behalf of First Nations community. Is it the activists that oppose it? I think what we need to do is we need to have conversations of exactly what it is they're opposing, because that's been very vague. Is it the entire pipeline? Is it certain parts of it? Like, which part of projects are you opposing and why? And once we get to those answers, we can better answer and better get to consultation and cooperation with everyone. But if we have outside activists coming in and setting up camp outside of our communities, they don't speak for us. And people don't realize that group does not speak for my First Nations community. And we need to kind of set a precedence of, okay, you have a First Nations community. This is clearly defined. Anybody outside of this community, do we need to consult with them? And when and where does that happen? So we need to be very clear on how this is all going to play out in the future. And that's not very clear right now.
Could I just make a comment?
Chris.
Yeah,
Absolutely.
so like Melissa, I mean, you hit it right on, nail on the head. I'm just going to say this because I know a lot of people are thinking of it, but governments need to understand that Indigenous people like myself and thousands of others are fully aware of the elected bodies that have come from the UN, that have come from the Sierra Club, that have come from WWF. They're all now elected. Those elected officials need to understand they don't represent those organizations anymore. They need to understand they represent me, whether we voted them for or not, the average Canadian. It does not matter where you've come from, because I've noticed that all these organizations have popped up everywhere. And when you do the background checking, you start to find out who worked for who. And they're now in the federal government. They're now in the provincial governments, in particular, a lot in British Columbia and a lot at the federal level. But the governments need to know. They really need to know who's connected to who. We're not blinded by that, because I'm telling you, this comes up in the conversations. And so many of us feel that's what's influencing policy. And it's damaging our country. It's damaging the relationships between provinces It's damaging relationships between communities. So those individuals that got elected, they need to understand, if you're going to be there for all of us. Because at the end of the day, if you're there, you shouldn't be worried about whether or not you're getting elected next election. You went there on a promise, but at the same time, you got to understand we could grow the economy while we protect the environment.
That's really great. You folks have been just wonderful. I'm going to give you a last chance to answer one question. It's really, really simple. Given the state of public and Indigenous discussion and debate about Bill C-15, what one piece of advice would you give to the government of Canada about how to proceed with UNDRIP? So basically summarize everything we've talked about. You have about a minute each. Heather, you're going to go first because I know you're going to take more than a minute.
I'm going to take 2 minutes. So I recommend that they amend it in a way, and hydro, forestry, mining, petroleum, they've all provided suggestions on amendments in a way that it doesn't deter resource development. Now, people say Indigenous rights are more important than resource development, and I agree. But what people don't appreciate is that Indigenous economic rights are going to hinge on them being able to access capital to own their own projects, to run their own projects. And when Indigenous communities, and they started to do this, go and try to get investment for their own resource projects, they're coming up with risk premiums, and they're coming up with huge interest rates because they are not competitive, because projects on Indigenous territories in Canada are so hard to get through. And so when we add all these bills and legislation and regulatory approvals that makes it harder to do business on Indigenous territories, that means we make it harder for them to have their own economies and to have their self-determination. What do I think will happen? And my greatest hope is the Senate proposes a few amendments and the Liberals, adopt a few of them. But it's already gone through the third reading on the House. I feel like, the horse has left the barn on this one.
Thanks, Heather. Melissa, to you. What's the one piece of advice you're going to offer to the government of Canada on how to proceed with UNDRIP?
We need to make it right the first go around. Otherwise, we're going to be in court. It's not going to work. And it's getting off on a really wrong foot. So if we cannot even make an amendment at this stage, what's it going to look like a year from now, 5 years from now, 10 years from now? Are we going to have more court cases on our hands? Are we going to be holding up projects that would normally have been in place within 5 years? Are we going to be shutting down industries? Like, how is this going to play out? And how is this going to look if these issues aren't addressed today, now, and before it goes into full legislation?
Thank you very much. That's very clear. Chris, last word to you.
Well, listen, I said it and I'll say it again. They need to go back to their rightful title holders. They got to bring them to the table in order to make this work. It's one of those things where if you go now, you have a fractured foundation right now, and if you try to build on a fractured foundation, your house is going to start to fall apart. So they need to go back, go speak to those individuals, like Chief Harold Layton of Metlakatla, like Mayor Gary Reese of Lackawanna, and all those other communities that have a great concern of what's happening. That's what I would do. You want to start on the right foot. You want to start on a good foot. And those leaders will be in a position to start welcoming other communities to start doing business.
Well, folks, this has been quite a remarkable afternoon. And Chris, Melissa, and Heather, I've got to thank you very, very much for very thoughtful and very passionate sort of descriptions and issues and answers and everything else. And everybody who joined us today, thank you very, very much for coming. Macdonald-Laurier Institute was created by Brian Lee Crowley and his supporters with the idea of discouraging bad public policy and encouraging public policy debate. And I'm sure Brian would be very proud of the conversation we've had here today. It's exactly the kind of informed and engaged debate that we have to have in Canada, not just about Indigenous issues or UNDRIP, but about all issues. So we gathered here today to talk about understanding UNDRIP, challenges to legislating the UN Declaration on the Rights of Indigenous People. I hope you all have been as informed and educated as I have been. This has been a very exciting and dynamic sort of conversation. Please join Macdonald-Laurier Institute in our further conversations. And just to give one last plug to Heather, because she only plugged it a little bit, Heather Exner-Pirot just produced a report on sort of the current state of Indigenous people in the resource economy. Excellent report available for free on the Macdonald-Laurier website. And I think it's one of these parts that you're hearing a bunch of voices that I think are ones we don't hear enough across this country, of people who are looking for a future within Canada, looking for economic opportunity, looking for a chance to sort of balance rights and the meeting the social needs and the cultural needs of the community. Chris, Melissa, Heather, you've been just fabulous. Thanks to all the staff at Macdonald-Laurier Institute for helping us with this program. And with that, I will sign off and thank everybody for joining us today.